Good evening. This is John Milburn for week 9 in Laws 12063, Advanced Statutory Interpretation and Drafting. Well, I do hope that you've all received your feedback for the first assessment and the marks that go with it, of course. If you have any questions, comments, please feel free to raise those during these sessions or through UCrew, or if you wish, send me an email. I'm happy to always have a chat. I do want to put an emphasis as we proceed through this unit on how you might go about preparing the second part of your assessment, which builds, of course, on the first. So there'll be a strong emphasis on that point. So my aim is to make what we do as practicable and useful as possible. This week, we're continuing in relation to our discussions about operative terms, which is the week 8 material. We hadn't quite finished. So I plan to finish that and complete week 9 material this evening. So we've got a lot to cover. If you have any questions, comments, please interrupt, please ask, and we'll go from there. Now, last week, we got as far as talking about some of the rules in relation to interpretation and drafting for operative terms. And we made comment that the courts may consider the consequences of an action as part of the interpretation process. And I should mention that tonight's material, at least in the first part, will mirror to some degree the content of your text. So please feel free to follow along, and I'll try from time to time to give you an idea of the relevant section of the text so that you can follow what I'm saying. So in dealing with the consequences, you'll recall that in Project Blue Sky, the High Court said that an act done in breach of a condition will not necessarily be invalid. One of the tests is as to whether the consequences are of particular type when considering whether the condition is void or not. What we can take from that comment of the High Court is that if great inconvenience or injustice might follow as a result of strict compliance with the provisions, then the courts are disinclined to hold that provision imposes an obligation, even though it might be couched in mandatory terms. Refer to Pearson Gettys at 11.19. Now, what does that mean for you in terms of drafting your material for the second exercise? What it says to me is that when you're drafting the material, you need to consider the question as to whether a failure to comply may lead to a circumstance where there is a severe consequence or even inconvenience to a person affected by the legislation. So when I read that material as a barrister, if you like, I look at that and I think in terms of how can I somehow argue against the imposition of this apparently mandatory provision by referring to the consequences and then seeking to effectively downgrade the mandatory provision into one which is something less than that. Now for you, you have to go one step further back in trying to anticipate in advance, if you like, what is going to happen as a result of the drafting that you prepare, and you have to ask yourself, is there a possibility of the consequences being such that the court, if they considered your legislation, your draft bill, might go against the wording that you've chosen to impose. And in this context, you can assume that I'll be the court, that I'll be looking for those sorts of things. And if I see the word must or shall in your material, I'll ask myself whether great inconvenience or injustice might follow by strictly complying with that provision, in which case I may then, in my own mind, read it as may rather than must. I hope that makes some sense, and it's meant to assist you in terms of your drafting. Now in the text, the authors refer to Simpson against the Attorney General, a New Zealand case. We mentioned this briefly last week. The Constitution used the word shall in relation to relevant provisions, but the court held that they were directory, non-mandatory provisions And the purpose and the reason it came to that conclusion is that if it was to be held mandatory, it would have caused extraordinary inconvenience and ultimately would have not have served any purpose. Have a look at Clayton and Heffron, 1960 105 CLR, for an Australian context where similarly expressed views were provided by the court in relation to compliance with constitutional provisions. Now, words to the effect of. So a similar approach may be adopted in relation to certain statements, a requirement that certain statements be made. The court may assume that a statement to like effect without actually following the exact script may be sufficient. An English example from Lord Denning, Samuel Montague and Co. Limited against Swiss Air Transport, 1996 to QB 306. In the context of wording on a consignment note, Lord Denning said that the exact words could lawfully be replaced by words to that effect. However, as your authors point out, if the aim of the Act would be defeated by such an approach, then the court will require strict compliance. An example, WMC Resources against Lane, 1997, 73 FCR 366. In that case, the court was dealing with the obligation under an Act to give notice to persons of interest, whose interest may be affected, with a native title claim. Certain words, and they were obligatory. Failure to comply meant that subsequent steps were deemed invalid. Now, the next topic at 11.22 and 11.23, Pearson Gettys deal with the issue of private action as being more likely to produce invalidity than public action. So again, when you're drafting your material, bear in mind at whom these provisions are to be applied. If the action is imposed upon or affects private individuals, where there's a positive obligation, for example, imposed on an individual rather than a public authority, then the court will adopt a certain view as opposed to the other. So an example, Hunter Resources against Melville, 1988, 164, CLR 234. And there was a requirement for an applicant, an individual, for a mining licence to peg the claim, and the court said that requires strict compliance. So if you like, that was consistent with the general rule that the courts are more likely to be strict where the positive obligation is imposed on an individual rather than a public authority. And Greg, thank you, is following along, page 442 of the text at the bottom. Contrast that with the public authority approach as evidenced in Clayton and Heffron. In relation to the passing of a bill to abolish the New South Wales Legislative Council, the court said at 247 that performance of the public duty upon which the task is confided is such that a deviation would cause great inconvenience to the public is a powerful consideration. The rationale for that approach is that it would be unfair to expect an individual to suffer as a result of non-compliance in relation to a requirement where he or she had no control. Whereas in the decision of Hunter Resources, then of course the applicant for the mining licence did have control. Anyway, that's one rationale. I think arguably it's a little convenient, this distinction. Another case, Montreal Rail against Normanton, 1917 Appeal Court. The court said that where a provision of a statute relates to performance of a public duty, and in such a case to hold null and void that act in neglect of the duty would cause serious general inconvenience or injustice to persons who had no control, and it wouldn't promote the object of the legislature, It's the practice of the courts to hold such provisions as directory only and not mandatory, even though they're said to be mandatory. All right, let's continue. At 11.24, Pearson Gettys talk about provisions setting out protections for persons affected by the invalidity where there's a failure to comply. So where the provisions set out requirements intended to allow people to make representations relevant to a decision, such as through responding to allegations or making a review or setting out opposition to a proposal, then failure to comply will usually be interpreted as producing an invalid result. Courts in those circumstances require strict compliance. Have a look at Skur against Brisbane City Council, and the court said that there would need to be a clear indication in the relevant legislation to the contrary, otherwise it will strike out as invalid those decisions made that fail to comply with the strict requirements. Have a look at enactments relevant to court procedure at 11.25. The general view is that non-compliance with enactments laying out procedure will result in invalidity, but the court will consider the reality of the situation. Has there been any real inconvenience or injustice that might flow as a result of failure to comply with these procedural requirements? And bear in mind that courts and tribunals have power to determine their own process and can sometimes overcome these provisions that are, even if they're termed mandatory provisions. I think I mentioned in the Mental Health Review Tribunal, for example, there are mandatory requirements in relation to the giving of notice to an adult, to a patient, if you like, of a clinical review, but those are things that the tribunal can, through its own process, overcome in terms of procedural requirements. It's just an example. So the reason I'm going through this is partly to give my take on what's in the text, and you know how much I think of this textbook, it's excellent, but also to encourage you to think about these requirements in the context of what you draft and think about what you might include and whether someone like me is going to think about the ramifications of what you draft. Time limits, 11.26. Provisions requiring an applicant to commence action within a certain time is quite frequent. Usually it's accompanied by a power to extend in circumstances where a court may consider an application to that effect. So it would be unusual to have a blanket requirement that it must be a specified time and there is no ability to go beyond and consider applications beyond that date. Unlike my requirements for assessment work, where I do have a cut-off date and that's final. It's a bit different though. Pearson Gettys at 11.28, the impossibility of compliance defence to obligatory requirement. Courts will excuse strict compliance where compliance is simply not possible. The rationale behind that is that where compliance is not possible, that indicates that the requirement therefore must not be obligatory. That makes sense. Helen says, the test to be applied is the purposive test, whether the purpose of the legislation is done, whether a breach of the provision would be found to invalid. Yes, I agree with that. And that's probably a common theme, that much of this, you can look at it from the Project Blue Sky perspective about the purpose, the ultimate purpose. Because the courts have said in the negative, to contrast that, words to the effect, we would like to overcome these mandatory requirements, but we can't do that if it would defeat the purpose of the Act. So that is an overriding consideration, which is, I think, common to all of these things. So thank you for that, Helen. Waiver of rights under obligatory provisions, which is 11.29. A provision will impose an obligation on a person or body for the benefit either of the person or the public at large. If it's clearly for the benefit of a particular person, it seems reasonable that the person should be able to elect not to require strict compliance, and courts do adopt that approach. But if it imposes an obligation of public interest, the courts are far less likely to waive those requirements, those obligatory requirements. That makes sense. Compliance with forms. This is 1130 through to 1136 of your text. Legislation often prescribed forms for a particular purpose. Now note section 25C of the Commonwealth Acts Interpretation Act, which says that where an act prescribes a form, then unless a contrary intention appears, strict compliance is not required. Substantial compliance is sufficient. Keep that in mind if you're dealing with a Commonwealth agency or a court. Each case turns on its own facts in determining whether there has been substantial rather than only partial compliance. And the approach recognises, and coming back to Helen's point, that the legislature might not have intended any adverse consequences to flow from a breach of a statutory provision or procedure. Again, go back to Sker and Brisbane City Council. There was a failure to comply with the requirements for a town planning issue. The development application or approval failed to improve or include adequate provisions for the proposed development. It was the court held that was contrary to the town planning scheme. So there are cases where the courts have declared valid actions taken, even though there's only been partial compliance. For example, lodging a deposit with the court 13 days after a notice of appeal, instead of the stated mandatory 7 days, was held to be sufficient. Failing to comply with all aspects of procedure by a prosecutor in a committal does not necessarily result in the invalidity of proceedings. So again, the common theme here, I guess there's two. Number one, when the legislation says must or shall, that's not always the case. And there needs to be consideration as to whether the substantial or even partial, in unusual circumstances, compliance would be sufficient. And overriding that is this purposive test of Project Blue Sky. Let's look at a case. Hi, Siobhan. Nice to see you joining us. Thank you. ABC against Redmore, 1989, 166 CLR 454. The ABC failed to obtain ministerial approval before it entered into a contract. Its enabling act required it to obtain the ministerial approval. It didn't. ABC claimed it's no longer bound by that contract because of the failure. The court rejected that argument and said non-compliance with the Act did not render the contract illegal or unenforceable. The legislation was a direction to the ABC, which, if it was not complied with, had consequences for the ABC or its employees, but not the contract itself being affected. That's almost like the concept of indefeasibility in Torrens title, isn't it? Anyway, it's an analogy. A similar approach was adopted in the Project Blue Sky case itself, where in making a broadcasting standard, the ABC failed to comply with statutory directive. The court said it was not the intention of the Act that the standard should thereby be invalid, but still it was a breach of the Act, and a person adversely affected may seek an appropriate remedy to prevent the standard being enforced against it. DeMinimis, another conceptual approach, is to consider variations from statutory requirements might be to apply the DeMinimis approach. That is, a minor variation from the requirement should not be considered. So we're not really talking about substantial compliance there. We're just talking about this. It's of such insignificant factor that we shouldn't even bother about it. So what do we take from all this? There are three options available to a court. Number one, the court can say, in the context of something in a legislation that says must or shall, strict compliance is necessary. It's one approach. Another approach is to say substantial compliance is necessary together with this degree of substantiality. Or the third is that the condition is not the compliance is not a precondition to the action taken. A breach of the first two would result in invalidity, but no consequences flow in the third instance. So what's the process? According to the authors, what I take from it anyway, number one, courts construe the relevant statute. No problem with that. Number two, courts will often seek assistance from the terms of other statutes. Number three, the task is to determine whether the legislature intended a failure to comply with the requirement should result in the invalidity of the act done. Think Project Blue Sky, think purpose of test. Number four, once the legislation is construed, consider the result of non-compliance by reference to that construction. Again, Project Blue Sky. Any questions then in relation to the content of that chapter, which is the week 8 material? Are we all good? We'll move on. Okay, week 9, we're dealing with exclusions, defence machinery clauses. We're dealing with exceptions and defence clauses in statutes. Exception and defence clauses allocate the burden of proof. Machinery clauses are not the operative clauses, but the machinery clauses are the things that make the act work. And then we're talking about drafting, exception and defence provisions. Now there's no prescribed reading, but the reference reading is the Office of the OPC Council Commonwealth, the OPC Drafting Manual. I hope that we've all had a chance to look at that. That's an excellent resource in terms of your second assessment. We've talked about it before, we've raised it before. So now, for the rest of this evening, the week 9 material, if you're going to follow along with what I'm saying, go to the OPC website, and I'd encourage you to do that. If you're watching this as a recorded session, please do the same. So the www.opc.gov.au. So this is the Commonwealth Office of Parliamentary Counsel. So what's our aim? In the second assessment, we're drafting material. What are we trying to do? As always in law, the modern approach, avoid complexity. If you can keep it simple, do so. With me, you won't be rewarded by using expansive language and words that require me to go off to the dictionary. You will be rewarded by preparing something that is easily read and something that others could easily read and interpret. That's the aim, simplicity. And of course, that's the whole tenor. Even within the OPC, it has a whole section on plain language, and we discussed that earlier. I guess there's a bit of selfishness in that. From my perspective, I read a lot of material from students, and I read a lot of material generally. I like to understand it my first run through. I don't like to have to stop and reread and understand. So I'm sure you can understand that. So let's talk now about exceptions, defences, and these machinery provisions. For the operative provisions to work, we need a whole range of other things to keep them together. So there are the three types. Exception provisions are provisions that exempt a person or class of person from the statutory provision that would otherwise apply. So we have an operative provision. This is the normal situation. Then we have the exception provision. Here's where a person might be exempt. You probably have to include that in your drafting. A defence provision, if you've got something that has a prosecutorial element to it, relieves a person from liability from the statutory offence. And the machinery provisions are really just those practical things that need to be done to achieve the objects of the Act and make it work. So we'll just have a look at machinery provisions first. Again, this is in your study guide. Machinery provisions often establish statutory duties and discretions. A statutory discretion, is a power usually given to a public official by statute. A discretion is not mandatory. It implies a choice that can be made by the public official. But remember, of course, the whole Wensbury principles in terms of reasonableness and fairness, that even though there is a choice, that is often guided by statute, and there's usually a reference to may in terms of that. A statutory duty is imposed upon a public official, usually by statute. The duty is mandatory and usually accompanied by the word must. All right, so machinery provisions. I'll deal with those first and then we'll go on to the more interesting areas. So machinery provisions are formal provisions, process provisions, this is how things happen, authorising provisions, authorising through delegated legislation, for example, or responsibility provisions. Formal provisions are required as a formality for an Act of Parliament. For example, the short title. And in the notes, I think it says even the simplest of acts require formal provisions. So when you're drafting your material, you will need to have a long title, a short title. You'll need to have some sort of commencement provision. I know you'll say to me, but in the Acts Interpretation Act there's a deeming provision, but I want to see a commencement provision in there somewhere. And you'll need a purposes section. But I'm sure you would do that because it's pretty much in every act now. So if you don't have those, your act, as far as I'm concerned, is incomplete, but I know that you will complete something. You will prepare something that is complete. Process provisions, number 2. Ask yourself what needs to happen. The example in your study guide is the Environment Protection and Biodiversity Conservation Act, Commonwealth 1999, and there are a whole range of machinery provisions. As a little side plug, I do take environmental law. If you're interested in that area, it's a good unit to consider. Authorising provisions allow for the delegation, allow for the legislation to work, and then responsibility provisions. All right, so that's enough from the study guide. Let's go to the OPC website. I'm sure you all know it by now. And in particular, could you go to drafting resources? If you don't know what I mean, if you're watching this as a recorded session, before we go further, I'll just share the screen briefly so that you can see what I mean by the drafting resources provision. That should be pretty familiar to you now. All right, I'll stop the share. For the moment anyway. So the OPC provides a range of templates. And you'll see on the right-hand side, the drafting templates. We'll have a look at that tonight. The drafting templates are very useful. And in fact, I will share the screen so that you can follow what I'm doing on your own computers. It might be easier to do that rather than me describe what I'm saying. All right, so hopefully now you can see the OPC website. And you'll see that there's drafting templates. Let's have a look at those. Those templates will serve you well, I think, in terms of drafting material. Let's have a look at the, there's a user guide, so I won't go through that, but I will refer you to the bottom of the page and you'll see the thing called the principal instrument. Now, what you do is you use this template. I'll just open it up. Hopefully that will open in the same place. Use that template to create your formal provisions and no, it's not going to open in the same place. So I will have to share this and I'll do that now. you're following along, you're probably way ahead of me and you've already clicked on it. But I'll share this now so that you can see what I'm following. All right, so you now should see the draft template. This is what we call the principal instrument in terms of preparing Commonwealth legislation. You'll see the yellow highlights indicate the variable components for insertion of material. Now, we really don't have much excuse for failing to provide in your drafting the machinery provisions because they're there. This is a Commonwealth piece of legislation, mind you, but there's obviously similarity. And even a template in terms of the formatting of the text, repeal sections, and accompanying notes to explain in detail what it is that you need to include. I'll leave you to read that for yourself in more detail. The next thing that I want you to do is have a look at the authorization template. Now, this is the template that you use if you're preparing authorization provisions. So you should be able to find that. It's 2 up and again, a Word document. The authorization provisions are useful if you're authorizing someone to have particular powers or to engage in certain activities. I'm not sure that I need to share this with you. I'll just, again, hopefully you're just finding that for yourself and you can look through it. So it has some explanations and you'll see on, I think, the 3rd page, a specific note as to how to draft the document in terms of authorizing someone to exercise certain powers. If you have any questions on that, please let us know. You'll see that there's reference to section 15, there's reference there to how the provisions should operate in practice. And as I said, there's some specific examples about how the person should undertake the work that you confer upon them. The next one is delegation. It's 2 from the bottom, and this is a template that you use if you're delegating powers or functions or duties. Check the delegation provisions in the Act or the instrument and insert in accordance with the terms of the provisions. A delegation is not usually given to a particular person. It's usually given to someone who holds an office. So if you are delegating, keep that in mind, or it might be a particular class. For example, SES employees or acting SES employees may be delegated certain powers. When you're reading the material, look at the accompanying notes. If you're following along now, you should be able to find those accompanying notes. And you'll see why the template is to be used, how it's authorized, and it talks about the name of the Act. So there are protocols in terms of the legislation. That is the delegation material contained within it. So for example, in 2.1 it says, a delegation under the Classified open brackets Publications, Films and Computer Games Act 1995 would include the words classification open brackets publication, films and computer games in the instrument name. I guess that's pretty obvious, but it's a matter of following those protocols. Have a look at part 3 of that material and you'll see in the yellow highlighting specific text to be inserted if you are delegating powers to a person, a title, to an office, if you like, or a class of persons. Again, don't delegate to an individual person. make it a class or someone who holds a particular office. Now, the next thing is the word notes. Has anyone looked at the word notes? And I'll try and find them. The word notes. If I just go back, so the OPC provides a series of word notes. These are very useful. And, oh, there's a trick to this. Here's how you find it. I'll share the screen for this one. See, because when you look at the drafting resources page, it took me a while to find this, but I found it. You'll see that there are 6 tiles. But if you go to the drop down, there are actually 7 drop downs. The top 6, 1, 2, 3, 4, 5, 6, match the 6 that you can see, but there's a 7th, you see, word notes. So click on word notes. This is a very useful resource. And you'll see that there are a series of word notes that will help you in terms of drafting. It provides template styles, examples, and formatting rules. For example, if you're following along, have a look at WordNote 4.2, which provides the formatting rules for legislation and other instruments drafted in the office of the OPC. All right, I'll leave you to read through those, but clearly, for example, if you're including formulas or tables in your material, then you'd want to consider those. What else is relevant? So, yep, table of contents in legislation, tables, formulas, templates about styles, and formatting rules for legislation. I'll stop the share. Now, we have already spoken about the OPC Commonwealth Drafting Manual, and that will provide information that you need about drafting the format of legislation, bills, instruments. It has the style manual as well. And for the purpose of this week's topic, I would like you to see attachment A, which is pages 31 through to 35. It deals with the components of bills and other instruments. Now, has anyone been able to find that yet? And we're talking about the drafting manual. So we need to go back into drafting resources, go into the drafting manual. Takes a little while to get there, but I'd like you to look at attachment A, which is pages 31 to 35. Can anyone tell me when they find it? Your internet might be faster than my internet, so I'm trying to get there now. I've just made a note to myself to do that. So when you find it, you'll see that the components include the layout and rules relating to chapters, parts, divisions, sections, subsections, paragraphs. Have we found it yet? Yes, Helen's got there. Any others? Helen, is page 31, isn't it? Am I correct in that? Okay. All right, Neil's found it. Good. Okay. So I won't highlight this, but if you're following along, you'll see that it talks about the components of bills and then sets out chapters, parts, divisions, subdivisions. Now, given the word count for your second assessment, you probably won't have time to go into all of these, but you'll see that it provides information about other components such as preambles, definitions, notes, tables, formulas, and penalties. So really quite useful information. And if you look in the table of contents, you'll see at a glance what it is that I'm talking about. All right, now the next thing to look at is drafting directions. And while I'm going through this, has everyone actually looked at these previously? Yes, no? All right. So have a look at the drafting directions. Again, we'll go back to the drafting services. I'll highlight what I mean by this, and I've got it on the screen. I think this is the one. All right, so drafting the OPC drafting directions look like this. Can you see that? It's maybe a bit small. But various directions from 2006 onwards about the way in which you present your material, and this supplements the drafting guides and manuals that we've talked about already. Then consider OPC Drafting Direction 1.3, which deals with commencement provisions. So I'll share the screen on this. So Drafting Direction 1.3 sets out the way commencement provisions are to be dealt with. And again, I'll share the screen just so that you know what I'm talking about. If you haven't already found it, I would like you to attempt to find it. All right, so can you see that? Parliamentary Council Drafting Direction number 1.3, and this is just one of the drafting directions that I've selected for you. So it provides for example, commencement provisions, and it deals with things like retrospectivity, etc. So Section 12(3) of the Legislation Act 2003, for example, allows for retrospective commencement of legislation. Subsection 12(2) of the Act provides for a provision of a legislative instrument does not apply in relation to a person to the extent that the provision commences before the day in certain circumstances. Can be overcome, but needs special methodology in drafting. So I urge you to look at that material and in particular Drafting Convention 1.3. Again, I'll share the screen. I'll stop sharing the screen. Have a look at Drafting Direction 1.5 that deals with definitions. And we're almost finished for tonight. So there's a bit of homework to do, but it may be that what you're looking at through this material, through the drafting directions, will supplement what you've already prepared if you've started your assessment. If not, it will give you hopefully a head start on the material. So Drafting Direction 1.5 deals with definitions, and the whole idea, of course, is that legislation is easier to understand if we have particular terms that are defined, and the reader of the material can be confident that where we have an expression used, that expression is used consistently throughout the legislation. So, of course, your job in drafting material is to ensure that there is that consistency, there is that aid to ease of reading, it assists in economy of words, and it should hopefully make things easier. But and Siobhan says there's a lot to consider. In real life, how long would you get to do this? I don't know, because I've not drafted legislation previously. But don't worry, you haven't got a huge word count, so some of these you can look at almost as a checklist. But sometimes I think if you go into this, into these templates in particular, you might find that makes lives so much easier. Just be a word of warning when it comes to definitions. You might be tempted to define everything, but avoid that temptation. If an expression is ordinarily used in a certain way, then don't define it. If, for example, you use the term contract in your legislation, in your material, don't define it. We know what a contract is, generally speaking. If there's a particular reason why you're defining it, if there's something against the norm, then do that. And also, there's no problem in using acronyms that we're well aware of. So, for example, GST, it's commonly used, it's understood, you can do that. However, and this is my final comment for tonight, do take care for the purpose of the assessment about what you choose to put in as an acronym. For example, I don't want to see LOL. I'm sure you understand. All right. Do we have any questions? All good? Okay. Well, best of luck with your assessment piece. Continue to work any questions through UCrew. Remember, of course, that for your final assessment, the 15%, I'm going to rely on you to provide me with the content of the material that you have added. So keep a separate, if you like, Word document. There's no word count. It can be 100 pages, I don't care. But if, for example, you upload something into UCrew, or you add something into the discussion forums by answering a question on the weekly problems, would you please, at the same time as doing that, cut and effectively paste it into your document? You can make it easier for me by adding, say, a table of contents. Make sure you paginate the document, give it a nice look. You know that I like to see those things as well. All right, and Siobhan will be LOL after reading this material. All right, okay. Any questions or all good? All fine? All right. Again, thank you for joining me this evening, and we'll see you next week. All the best. Bye then.